As Donald Trump campaigns for another potential term in the White House, the specter of his past administrative actions looms large, particularly his approach to key federal agencies and regulatory bodies. Known for appointing loyalists and reshaping agency mandates, Trump's 2016 to 2020 presidency illustrated a concerted effort to reduce regulatory oversight across fields as diverse as environmental protection, labor rights, and consumer safety. Yet, ironically, a Supreme Court ruling, notably led by Chief Justice John Roberts, has introduced an unexpected roadblock to Trump's ambitions. This video will explore how the Supreme Court's recent decision dismantling the Chevron doctrine, a legal principle that granted administrative agencies considerable leeway, could inadvertently impede Trump's plans to restructure and control federal agencies should he regain office. In this piece, we'll dive into the details of the Chevron doctrine, discuss how the court's decision may limit Trump's power, and analyze what this means for American governance moving forward. For those who fear the unchecked influence of a radical agenda, this Supreme Court decision could be a potent tool to counteract any attempt by Trump to place ideological puppets in power. Understanding the Chevron doctrine and its demise. The Chevron doctrine, established in the 1984 Supreme Court case Chevron USA, Inc. v. Natural Resources Defense Council Incorporated, was a landmark in administrative law. It gave federal agencies substantial authority to interpret ambiguous laws passed by Congress, under the assumption that agencies possess the expertise to make technical decisions in their respective fields. If a statute was ambiguous, courts would defer to the agency's interpretation as long as it was reasonable. This doctrine became a bedrock principle for agency independence, allowing agencies from the Environmental Protection Agency, EPA, to the Securities and Exchange Commission, SEC, to act with considerable autonomy. However, conservatives, particularly within the Federalist Society, have long opposed the Chevron doctrine, arguing that it places too much power in the hands of unelected officials. Their preference is to limit agency power and instead centralize authority in elected branches, particularly the executive. In a recent move that surprised many legal observers, Chief Justice John Roberts led the Supreme Court in weakening the Chevron doctrine, stripping agencies of this deference. Without Chevron, courts are no longer obligated to defer to an agency's interpretation of ambiguous law, potentially putting Trump's administration at a disadvantage. Should he attempt to fill agencies with loyalists who seek to roll back protections on environmental standards, labor rights, and consumer protections, this ruling could stymie his efforts, forcing agencies to defend their interpretations in court without the previous level of judicial deference. The power shift from agencies to judges. The removal of Chevron deference effectively places greater responsibility in the hands of federal judges. Now, instead of agencies interpreting vague statutes, the judiciary will have the final say. This shift is both a boon and a threat to Trump's ambitions. On one hand, it could empower his administration if conservative judges align with his deregulation agenda. On the other hand, it opens up an opportunity for opponents to file lawsuits in federal courts, particularly in jurisdictions known to have a more liberal leaning. Federal judges appointed by Democrats, such as those in the Second Circuit in New York or the Ninth Circuit in California, could serve as obstacles to Trump's plans. In these courts, activists and advocacy groups could challenge Trump's policies, forcing agency heads to defend their positions in a more skeptical judicial environment. Potential impact on key agencies. If Trump regains office, his appointments to critical agencies could encounter formidable legal challenges. Below, we examine the potential impact on several major federal agencies. Environmental Protection Agency, EPA. During Trump's first term, the EPA saw dramatic policy shifts, with numerous regulations on pollution and emissions either relaxed or entirely dismantled. If Trump's team attempts similar moves again, this new Supreme Court precedent would allow opponents to bring these changes before a judge. For instance, if the EPA under Trump seeks to weaken standards on methane emissions, a major contributor to climate change, Opponents could argue that the agency's interpretation of relevant statutes is too extreme or unreasonable, effectively stalling or reversing the changes. Department of Health and Human Services, HHS. Trump's stance on health care has involved rolling back provisions of the Affordable Care Act and curbing regulations around Medicare and Medicaid. Should he appoint officials who attempt similar policy reversals, the Chevron decision would allow federal judges to scrutinize these actions closely. This could prevent any immediate, sweeping changes to healthcare protections and require Trump's administration to build a compelling legal argument for each rollback. Securities and Exchange Commission, SEC. The SEC plays a vital role in regulating the financial markets and ensuring fair practices. During Trump's presidency, the SEC relaxed various regulations, favoring Wall Street and large corporations. Without Chevron deference, any radical policy shifts at the SEC could face increased judicial scrutiny, making it difficult for Trump appointees to implement drastic deregulation measures without facing legal battles. Internal Revenue Service, IRS. The IRS could also see significant changes under Trump, as his administration has historically favored tax cuts for corporations and the wealthy. However, any new attempts to restructure tax enforcement policies might face opposition in court. Without the benefit of Chevron, Trump's appointees would need to defend these policy changes in a court system that could be less sympathetic, particularly in blue states. Using the courts to counter Trump's agenda, a legal strategy. For those opposed to Trump's policies, the Supreme Court's recent ruling offers a strategic avenue to resist potential agency overreach. Public interest groups, Democratic leaders, and advocacy organizations can now leverage this decision to challenge agency actions they see as harmful. The pathway would involve filing lawsuits in favorable jurisdictions, where Democratic-appointed judges preside, and appealing decisions through the circuit courts with liberal majorities. The goal for these groups would be to bring cases before courts with more progressive leanings, such as the Ninth Circuit in California or the Third Circuit in New Jersey. From these courts, cases could proceed to the Supreme Court, where the ideological makeup could still present challenges. However, the ruling's impact means that Trump-aligned agency heads would face significantly more roadblocks than before. The role of Chief Justice Roberts, a surprising ally? Chief Justice John Roberts has often found himself in the center of ideological battles within the court, straddling conservative principles with a respect for institutional continuity. His role in undermining the Chevron doctrine reflects a nuanced approach to limiting administrative power while safeguarding judicial oversight. For opponents of Trump's agenda, Roberts' recent rulings might serve as an unexpected tool in countering potential excesses. This ruling represents a form of legal jujitsu, using the conservative court's own decisions against a future conservative administration's attempts at sweeping policy changes. By allowing judges greater authority over agency interpretation, Roberts has inadvertently empowered those who wish to challenge Trump's proposed agency alterations. What this means for democracy. The weakening of the Chevron doctrine reflects the ongoing battle over the separation of powers within the U.S. government. For decades, administrative agencies have been able to interpret and enforce regulations with relative independence, guided by expertise and insulated from the political winds of each new administration. But now, with the courts assuming more control, the landscape has shifted. On one hand, this shift could ensure that agencies do not overstep their bounds, keeping power checked between the judiciary and executive branches. On the other, it risks creating a judiciary that is deeply entangled in policy debates, leading to inconsistent rulings based on regional ideologies rather than uniform national policy. The Supreme Court's recent ruling dismantling the Chevron doctrine has created a complex legal landscape that could play a crucial role in the upcoming presidential term. For Donald Trump and his supporters, it represents both an opportunity and a liability. While the ruling may allow for agency decisions that align with Trump's policies to stand unchallenged in some conservative courts, it equally empowers progressive judges and advocacy groups to challenge those same decisions elsewhere. For Americans concerned about the overreach of executive power, This ruling offers hope that Trump's attempts to consolidate agency control will face substantial legal hurdles. Chief Justice Roberts' unexpected role in limiting agency deference has handed opponents of Trump's potential agenda a powerful weapon. In this new judicial landscape, each policy shift Trump attempts could become a protracted legal battle, potentially slowing or even halting the radical transformations he envisions. As Trump vies for power and looks to remake the administrative state, the courts may prove to be the ultimate safeguard against sweeping, unchecked changes. The Supreme Court's decision has opened the door for opposition, making it clear that the battle for America's future will be fought not only at the ballot box but in the very halls of justice.